Sinta.
Waalaikumsalam, Bu Eni.
Bu Sinta Damang.
Alhamdulillah.
Selamat pagi, Prof. Abu. Good morning.
Selamat pagi. Apa kabar?
Bu Ranti.
Baik. Sehat, Prof. Abu?
Alhamdulillah.
Alhamdulillah.
Tapi belum sepenuhnya karena terkena COVID dulu.
Oh iya, tapi sudah pulih ya, Prof?
Ya, tapi baru 20% lah.
Iya. Terus pemulihan ya, Prof ya masih ya.
Boleh.
Sehat, Prof?
Boleh, insyaallah. Gitu kan.
Assalamualaikum, Bu Dr. Ranti.
Pagi semuanya.
Bu Dr. Widati. Di mute semua. Abu Kepala Mustafa Damang.
Ini Prof. Abu di Malaysia COVID masih banyak, Prof?
Banyak, tapi ya kebanyakannya tidak serius. Jadi kalaupun banyak, ya yang kategori 1 yang tidak ada simptom tidak.
Selamat pagi, Prof.
Selamat pagi, Bu Rika, apa kabar?
Baik, Prof. Bu Sinta, selamat pagi,
Bu
Ibu
Dr.
dan
Rika.
Bapak semua.
Terima kasih.
Ya, selamat pagi.
Apa kabar?
Assalamualaikum, selamat pagi, Bapak Ibu. Salam sehat.
Salam.
You know our love was meant to be the kind of love to last forever. And I want you here with me from tonight until the end of time. You should know everywhere I go, always on my mind, in my heart, in my soul. Baby, you're the meaning in my life. You're the inspiration. You
Iya, apa sih kalau selanjutnya?
From tonight until the end of time, you should know. Everywhere I go, always on my mind. You're in my heart, in my soul. You're the meaning in my life. You're the inspiration. You bring feeling to my life. You're the inspiration. Wanna have you near me? I wanna have you hear me say it. No one needs you more than I. No one needs you more than wanna have you near me? I wanna have you hear me say it. No one needs you more than I need you. You're the meaning in my life. You're the inspiration. You bring feeling to my life. You're the inspiration. When you love somebody to the end of time. When you love somebody, always on my mind. No one needs you more than I. When you love somebody to the end of time. When you love somebody, always on my mind. No one needs you more than I. When you love somebody to the end of time. You know our love was meant, the kind of love to last forever. And I want you here with me from tonight until the end of time. You
Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, and good morning to all participants of Studium General. We will discuss about data protection laws of the world, principles, fundamentals, and practice with Professor Bakar Munir. This event is organized by the Information Technology, Communication, and Intellectual Property Law Department, Faculty of Law, Universitas Padjadjaran. Good morning and welcome to the Honorable Mr. Professor Abu Bakar Munir as our speaker at the Studium General and Dr. Sinta Dewi Rosadi, SHLM, as the head of Technology, Information, Communication, and Intellectual Property Law Department, Faculty of Law, Universitas Padjadjaran. And I also give my warmest regards to all the lecturers of Technology, Information, Communication, and Intellectual Property Law Department, Faculty of Law, Universitas Padjadjaran. Good morning, and let me welcome everyone to today's Studium General. First of all, let me introduce myself. My name is Rizka Livia Zahra, who will be your Master of Ceremony in today's General.
Si orang luar.
To start our program today, let's pray together according to our respective beliefs and religions. Praying begins. Okay, before we move on to the next event, I will read the rules for the participants that must be obeyed so that our event can run well and smoothly. First, Participants and the committee are required to comply with the rules, maintain politeness during the stadium general. Second, during the event, all audio or mic features must be disabled. If needed, the audio or mic feature can be opened at any time by the committee. Third, during the event, please turn on the camera to all the participants. Fourth, participants who want to ask questions can send their question in the chat column with the format name_question. Last, the link of each certificate will be sent by the committee at the end of this event. Next, we will listen to the national anthem of Indonesia, Indonesia Raya. Attendees are expected to sit down and prepare. Thank you to the participants. Next, we will listen to opening remarks from the head of TIK-KI, Dr. Sinta SHLLM. To Dr. Sinta, the floor is yours.
Okay, thank you Rizka for the introduction. Assalamualaikum warahmatullahi wabarakatuh. Does my voice is clear?
Yeah.
Yeah, thank you. On behalf of the Dean of Faculty of Law, UNPAD, Dr. Idris, who unfortunately is not able to come, Prof, because he has a task for his student final exam, PSG. So he sent his best regard to you. And thank you for the invitation to give a public lecture of this very important issue, both globally and also in Indonesia. Once again, Prof, we are grateful to Prof. Abu Bakar who accepting our invitation as one of our international visiting professor, even though has not yet 100% recovered, Prof. Thank you so much. Hope you will get well soon. And in today event, Professor Abu Bakar will give a lecture on data protection regulation. In the word, principle, fundamental, and practices. And also thank you very much for all the professor from Department of Information Technology and Communication and Intellectual Property who are attend of this lecture, and also to my student. The student who are already attend in today event is about 273 students, which is come from 2 classes. This is from they are from cyber law class and data protection classes. But maybe half of the student will left on the half of your session because they have another course. So thank you, Prof. And to my student, this is very important occasion, and please do make best of this opportunity. And we will learn and very issue data protection regulation in globally, and also please raise any question if there any thought that you want to ask question. And from a final comment, thank you for the association, student association of department TIK-KI, who work hard. Thank you guys for coordinating this session. And I will end my opening remarks. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you to the Honorable Dr. Sinta for your opening remarks. Before we move on to the next session, let's take a photo together first. For our lecturers and fellow students are expected to turn on the camera feature and prepare for a group photo. To the committee, I invite you to lead this group photo session.
Okay, first slide. I will count from 3. 3, 2, 1. Next. 3, 2, 1. Next. 3, 2, 1. Last. 3, 2, 1. Okay.
Okay, thank you to the committee that has been leading our photo session. After the opening of the Studium General, next we will start the public lecture with the theme Data Protection Laws of the World, Principles, Fundamental, and Practice. Before starting the event, please allow me to read our moderator CV for today. We will lead our presentation session. Dr. Laina Rafianti SHMA is a lecturer at the Information Technology, Communication, and Intellectual Property Law Department, Faculty of Law, Pajajaran University. She got her bachelor to doctoral degree at Pajajaran University. Her main field is intellectual property laws, especially copyright and traditional cultural expression. From 2005 until now, she teaches at the Faculty of Law. Some of the courses are intellectual property law, copyright law, trademark and geographical indication law, telecommunication and digital media law, as well as international contract law, all the I's collected she did. Besides being active in the Center for the Study of Intellectual Property Regulation and Application at Pajajaran University, Laina is a member of the Association for Teaching Property Rights Intellectual in Indonesia and has participated in international academic activities for intellectual property law lectures such as IPIRA or Intellectual Property and Innovation Researchers of Asia Network. Active in training activities in the field of intellectual property, several activities that she has participated, including the Geographical Indication Training, the Second Asia Pacific Workshop on Innovation, IP, and Competition at National Law University India, and WTO Colloquium Asia. Dr. Laina too has many publications and journals. In 2017, she published The Protection of the Performing Arts in Indonesia, including in the digital age. In 2018, she published resensi buku Sejarah dan Politik Hukum Hak Cipta. In 2019, she published Policy Framework for the Protection of Cross-Border Traditional Bosong, a case study. In 2020, she published Harmonizing Cultural Diplomacy and Commercialization of Traditional Cultural Expression, case study on illegaligo. In 2021, she published Swing the Angklung Tube in the Digital Economy Era based on intangible cultural heritage and intellectual property perspective. That was the reading of our Meritor CV. To Dr. Raina, the floor is yours to lead our next session. Thank you.
Thank you very much, Rizka Alivia. A very good morning for everyone. Professor Abu Bakar Munir, how are you, Professor?
Alhamdulillah.
Alhamdulillah, it's nice to see you, although we are on screen right now.
Yeah.
And I would like to say hi to Ibu Dr. Sinta Dewi as the head of the Department of IT and IP Law, and Dr. Tasya Safirani Taramli, the head of Cyber Law and Digital Transformation Center Studies, and Ibu Miranda Risang Ayu Palar, SILLM PhD, the head of IP Center of Regulation Application Studies. And also here, we already have Ibu Dr. Rika and Ibu Dr. Eni, Pak Dr. Muhammad Amirullah, Ibu Helita, Ibu Dr. Ranti. Thank you for joining us today. And also Pak Mustafa Hafaz, Pak Mustafa, good morning. And all of our beloved students from two classes, as Ibu Sinta mentioned. They are from Cyber Law class and Privacy on Digital Media class. Oh, also Ibu Widati. Hi, Ibu Widati, good morning. And before we start this Studium Generale, I would like to read the curriculum vitae of Professor Abu Bakar Munir. Professor Abu Bakar Munir is an internationally renowned scholar, expert and consultant on cyber law and data protection law. He was a professor of law at the Faculty of Law, University of Malaya. He is the author of several books. Those are Cyber Law Policies and Challenges in 1999, and Privacy and Data Protection 2002, Internet Banking Law and Practice 2004, and Information and Communication Technology Law, STAT, Internet and Information in 2010, Personal Data Protection in Malaysia, Law and Practice 2010, Data Protection Law in Asia 2014, and Data Protection Law in Asia, second edition 2018. He speaks extensively at seminars, workshops, and conferences around the world, including those organized or hosted by universities, such as the NUS, Oxford University, Cambridge, MIT, etc. Google, Facebook, Microsoft, Yahoo are amongst the participants of his talks and presentations. He represented Asia in the Europe-Asia Dialogue on the Digital Economy at the Johns Hopkins University in Washington, D.C. Professor Abu Bakar Munir has been far and wide consulted by the government and private entities around the globe. He was appointed as the advisor to the government of Malaysia and was instrumental in the crafting and passing the Malaysian Personal Data Protection Act 2010. He was seconded as the IT law advisor and principal consultant to the government of Dubai, where he led an international team of consultants in developing and drafting several IT legislation to facilitate the Dubai Internet City multi-billion-dollar IT project. He assisted the government of Indonesia in developing the draft on law personal data protection. That's why the relation between Prof. Abu Bakar Munir and Ibu Sinta, also Ibu Rika, is already really close. His current appointment include adjunct professor Ahmad Ibrahim Kuliah of Law, International Islamic University, Malaysia, Adjunct Professor, Faculty of Law, Universitas Indonesia, International Visiting Professor of Cyber Law and Data Protection Law, Faculty of Law, Universitas Pajajaran, Indonesia, of course, member Data Protection Appeal Tribunal, Malaysia, co-founder Asosiasi Profesional Privasi Data Indonesia, co-founder and director Bali International Arbitration and Mediation Center, Director of Privacy and Cyber Security, Kuala Lumpur International Chamber of Commerce, a member of the Academic Advisory Panel, Asia Pacific Institute of Digital Economy, Tokyo, Japan, Resource Consultant, Harry Ellis Partnership, Singapore, Senior Advisor, Sender Law Firm Jakarta, KNK Advocates Jakarta, Veritas Law Bangkok, Bin Bahyan Advocates and Legal Consultancy Dubai, and Diwan Al-Kubilah Law Firm Riyadh, and also an expert team member, Hunt and Partner, Riyadh, Kingdom of Saudi Arabia. That's why Ibu Sinta said that Professor Abu Bakar Munir is an international scholar that really have a lot of experience. Professor Abu Bakar, without any thoughts, the floor is your, Professor. Would you like to share your screen, or we will help you with share screen?
Yes. Bismillahirrahmanirrahim. Assalamualaikum dan selamat pagi. Thank you so much. Thank you so much for having me here. So first and foremost, I would like to thank Fakultas Hukum Universiti Pajajaran for giving me the opportunity to talk on this topic. I think it's timely because of the fact that the Indonesian government is still trying to finalize the RUU on data protection. And because of the fact that there are so many interesting developments around the world on this topic. So thank you so much again. And please bear with me. I just recovered from COVID-19, but inshallah I can manage. Then if there is any hiccup in relation to my voice, perhaps, you can accept, and please bear with me. Okay, let's get started. Can we share the slide? Okay. This is a topic that we have agreed upon between myself and the Ibu Sinta and the committee members, data protection laws of the world, principles, fundamentals, and practices. So what I'm going to do in this presentation is that to discuss the concept of privacy, and then the evolution of the privacy right, then privacy as human rights, privacy in religions, and then the importance of privacy and data protection regulations, and some practices or some comparative analysis of the data protection laws of the world or data protection regulations in different parts of the world. So that's what I'm going to do. As mentioned by Dr. Sinta, Ibu Sinta, I would like to have questions from the participants. Perhaps in that manner, we can discuss issues and then we can learn better. Okay, let's get started. First, about the concept of privacy. There are so many definitions given to the term of privacy. And I took this, I would regard this as one of the best definition, very comprehensive. Yeah, it is very comprehensive. Privacy is our right to keep a domain around us, which includes all those things that are part of us, such as our body, home, thoughts, feelings, secret, and identity. The right to privacy gives us the ability to choose which parts in this domain can be accessed by others and to control the extent, manner, and timing of the use of those parts we choose to disclose. As I said, this is one of the very comprehensive definition for the very basic concept of privacy. Next slide, please. This is from the Office of the Australian Information Commissioner, OAIC. According to OIE, OAIC, privacy is a fundamental human right that underpins freedom of association, thought, and expression, as well as freedom from discrimination. But OAIC admitted that it is hard to define privacy, and different countries offer different views and pseudo individuals. And according to OAIC, privacy includes the right to be free from interference and intrusion, to associate freely with whom you want, to be able to control who can see our information. Next slide, please. This is from Privacy International. As we know, Privacy International is a body trying to promote privacy, specifically data privacy. And it looks at privacy as human rights or fundamental rights. Privacy is a fundamental right essential to autonomy and the protection of human dignity, serving as a foundation upon which many other human rights are built. I tend to agree with this definition. Yeah, let's move on. The privacy in religions. So in the Islamic law, privacy principles are revealed or deducted from Quran, Sunnah, history, and culture. And there are some references to the terms privacy in Bible, as well as Jewish law. Next slide, please. In Islam, there are some basic fundamental rights in Islam. First, right to life, right to live in dignity, right to justice, right to equal protection of law, right to choice, right to free expression, and right to privacy, right to property, right to basic necessities, and right to reward. So, right to privacy is one of the very basic fundamental rights in Islam. Let's move on. So, in the Holy Quran, there are some provisions prohibiting individual, for example, not to spy on another in Surah 49, ayat 12. And then there is a prohibition not to enter any house except our own houses unless we are sure of the consent of the occupants. From Surah 24, ayat 27, I think this is Surah An-Nur. And then there is a provision saying that goodness does not consist of entering by the back door, so enter your houses by the main door. I think this is Surah Al-Bakar, ayat 189. Next slide, please. And then in Surah 24, ayat 58, it says, children who have not yet hit puberty should ask permission to come in at 3 times of the day. Before the dawn prayer, when you lay your garments aside in the midday heat, and after delivering prayer. So children will have to have permission to enter a room at 3 different times of the day. Next slide, please. In Hadith, there are some provisions or some Hadith saying, for example, the Prophet once said, he who looks into a letter belonging to his brother looks into the hellfire. So we are not supposed to look into a letter of someone else. If a man finds another person secretly peeping into his house and he blinds his eyes as a punishment, then he cannot be called to questions, nor will he be liable to prosecution. Come to anyone's door, he did not face it squarely, but face the right or left corner and stand with the wall. Basically, we cannot see directly into the house of someone. We have to stand not so direct in front of the door. So these are some of the hadiths on this basic concept of privacy. Next slide, please. Privacy as human rights, as we know, Article 12 of the Universal Declaration on Human Rights, 1948, it says, no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence. And there are so many other international human rights. For example, Article 17 of the International Covenant on Civil and Political Rights, Article 16, Convention on the Right of the Child, Article 8, European Convention on the Rights on Human Rights, and so many other instruments talking about the right to privacy. And in ASEAN, we have Article 21, ASEAN Human Rights Declaration. Okay, let's move on. In the Arab Charter, Article 21, then Cairo Declaration of the Islamic Organization, or OIC, Article 18. Next slide, please. This is interesting. If you look at this slide, the right to privacy has been argued by these two scholars and lawyers, Warren and Brandeis. And the article is still available. If you look at the Harvard Law Review, Volume 4, number 5, published on the 15th December, 1890. These two gentlemen argued that in the US, there is the right to privacy. So, as early as 1890, there was an argument saying that even in the US, there is a right to privacy. So perhaps you can explore and read further this article written by Warren and Brandeis. Next slide, please. There are different types of privacy. One is the right to be left alone. This is what Warren and Brandeis argued in their article. Then bodily privacy, privacy of communications, territorial privacy, and informational privacy. So we are going to focus on informational privacy. Let's move on. So informational privacy or information privacy is basically data protection or personal data protection. It talks about the rights of an individual to have control over our information. Information privacy is about promoting the protection of information that says who we are, what we do, and what we believe. So that's a very basic concept of information privacy or data protection. Next slide, please. Let's have a look at the reality check. I have to admit that data protection high on the agenda of the international community and national policy and policymakers as well as lawmakers. The United Nations in 2015 appointed a special rapporteur on the right to privacy. Perhaps Ibu Sinta still remember the special rapporteur who came to Jakarta and other parts of Indonesia to promote privacy and to assist in the drafting of the ROU. The United Nations Development Group has issued data privacy ethics and protection guidance notes on big data for achievement of the 2030 Sustainable Development Goal or 2030 Agenda. The United Nations General Assembly has adopted resolution on the right to privacy in the digital age. Data protection has been included in several international trade agreements, for example, RCEP, TPP, etc. So you can have a look at, for example, I think chapter 12 of the RCEP. Data protection regulation has been considered in several high-profile cases. For example, FTC or Federal Trade Commission in the US has fined Google $5 billion for breaching the privacy rules in the US. And numerous countries are drafting their laws or trying to review the existing ones. So this includes Indonesia. As I mentioned, Indonesia is trying to come up with the legislation. And as we know, there are issues that need to be addressed. And several global and regional organizations have issued or are developing multi-party agreements or guidelines on data protection. And I just give one example. UNICEF recently come up with the guideline called the Case for Better Governance of Children's Data, a manifesto in 2021. And WHO has issued contact tracing in the context of COVID-19. There are some principles regarding privacy and how countries around the world should protect privacy in the midst of fighting the COVID-19 outbreak. Next slide, please. Sorry, this is a replication of that one. Next slide, please. Have a look at this slide. Do you agree with this statement? This is a statement from World Economic Forum, I think issued in 2016. Data is the new oil. Do you agree with that statement? So I produced this slide to show that there is some truth in that statement by World Economic Forum by comparing ExxonMobil and Google. So if you look at the market capital of Exxon, 3.68.6 billion, and the market capital of Google, 3.7 billion. And if you look at the assets, ExxonMobil has got 68.25 assets, and Google, in terms of asset, is very low, 6.5 assets. But in terms of revenue, ExxonMobil, the revenue in the first quarter of 2015, the revenue was 4.9 billion. And for the same period of 2015, the revenue of Google is 17.3 billion. And another factor, Exxon needed 137 years to get there, to manage to get that profit or the amount of profit. And Google requires just 15 years to get that amount of profit in 2015. So the question that we need to ask is that, what does Google have? Okay. This is another interesting statement by Michelle Zhao. I think she was a data scientist with IBM. If data is the new oil, then we are all data wells and potentially valuable ones. I tend to agree with this statement. Yeah. Next slide, please. Have a look at this. Data mine is bigger than gold mine. I think it's quite true. It's very true, in fact. Yeah, because the amount of gold depreciates, the amount of data basically keep on increasing by minutes or by second. Because every activity on the internet, whatever you do, the data will be captured, or you will produce data. Next slide, please. This is what IBM Chief Privacy Officer used to say: privacy is good for business. Next slide, please. This is another statement saying that if we address this issue of privacy, it is good for business. Good privacy is good for business. Again, next slide, please. This is from Harvard Business Review. Privacy and security are converging. Here is why that matters for people and for companies. Next slide, please. Privacy will no longer be the merely immaterial or political concept it was once. Instead, privacy will begin to have substantial impacts on businesses' bottom line. For example, Facebook lost a whopping 119 billion in market capitalization in the wake of the Cambridge Analytica scandal because of concerns over privacy. To those who remember this case involving Cambridge Analytica and Facebook, I think we can still remember very well this case. Next slide, please. For the first time in Facebook's history, the founder, Zuckerberg, admitted that they have suffered losses. Yeah? Facebook has recorded the first annual fall in profit, not losses in that sense, basically reduction in profit. Yeah? Facebook has recorded the first annual fall in profit because of the privacy issue in 2019. Okay, next slide, please. There's a book written by John DiCilio, and the title is Privacy Means Profit. Do you agree with this statement? Perhaps we can discuss after this lecture or during Q&A session. Next slide, please. In terms of international instrument, international as well as regional instrument, there are already in place some instruments. For example, OECD Guidelines 1980, Council of Europe Convention 1981, EU General Data Protection Regulation 2018, APEC Privacy Framework 2015, and we in ASEAN, we have ASEAN Framework on Personal Data Protection 2016. EU General Data Protection Regulation 2016 replaced EU Directive 1995. Yeah, so don't get confused and argue that data protection is new in Europe, because EU GDPR replaced the old regime of Data Protection Directive 1995. Next slide, please. So you can have a look at the details later on. Yeah, this is from I think OECD report, if I'm not mistaken. Globally, you can see 66% of countries around the world with legislation, 10% countries with draft legislation, countries with no legislation, 19%, countries with no data, 5%. Okay, so that's the situation globally. In the US, as we know, there is no comprehensive legislation at the federal level. The law in the US are scattered around depending on the sector. However, there are some interesting development for the past 2, 3, 5 years or 3 years specifically. Some states in the US have enacted specific comprehensive legislation to protect privacy. For example, California, Colorado, and Virginia. And the state of Washington is in the midst of developing and having comprehensive law on privacy and data protection. Next slide, please. In the Middle East, some interesting development last year. Okay, last year, Saudi Arabia or Kingdom of Saudi Arabia, towards the end of last year, enacted Personal Data Protection Law or PDPL, before and followed by UAE 2-3 months after that. And of course, Turkey has enacted the law in 2016. In 2020, Egypt came up with the data protection law, Bahrain 2019, and as I said, Qatar in 2016. So the newcomers in the Middle East are basically Saudi Arabia, Egypt, and UAE, United Arab Emirates. Next slide, please. Now let's have a look at the principles of data protection. If you look at the regulations around the world, these are some of the common denominators or some of the common features of the legislation on data protection around the world. First, of course, general provisions, definition, and scope. Scope is very important because some legislations has got extraterritorial application, which means if you are processing data from outside the country, but you are monitoring the behavior of the data subject in that country, then the law will be applicable to you regardless of your location. Second, about data protection principles. This is the backbone of the data protection laws around the world. Some basic principles like access principle, disclosure principle, and principle of obtaining consent, and other principles like security principle and other principles. So that is the second common feature of the data protection laws around the world. The third one is rights of data subjects. Data subjects, you and me, will be granted certain rights, in our law, and these rights may include the rights to have access to the data, rights to have certain information about the organizations processing our data, the right to refuse profiling, the right to object sharing of data, the right to request for the data to be deleted or to be removed from our websites, and other rights, okay? Then grounds for processing personal data, as I mentioned, the basic element is that there must be, you have to obtain consent from the data subjects, and then there must be legal justification or valid reason for the data to be processed and collected by the data subject. The other element or the other common feature is that obligations of data controllers and data processors. So if you look at the data protection law around the world, they will specify the duties and obligations of the data controllers as well as data processors. For example, you have to protect the data. You have to put in place mechanism or measures to protect the data. You have to provide the mechanism for the data subject to exercise the rights and other obligations mentioned in the data protection laws around the world. The other common feature is independent supervisory authority. So if you look in the regulations around the world, basically there must be supervisory authority which can enforce the law without fear or favor. And last but not least, redress. So this redress can be in the form of financial penalty imposed by the regulator. Secondly, the civil actions that can be brought against companies. And then, of course, criminal penalties or pidana. Yeah. So there are three different forms of redresses here. One is penalty by the regulator. Secondly, civil action, and thirdly, criminal sanctions or pidana. So those are the basic common principles of data protection laws around the world, or common features of the regulations on data protection. Let's move on. So what I'm going to do for the next 5, perhaps 10 minutes is to do some kind of brief analysis or comparative analysis of the EU GDPR and legislations around the world, especially in Asia. Why EU GDPR? Some of you may ask, why EU GDPR? EU GDPR has been regarded as a gold standard. It has been regarded as a game changer in terms of data protection law or privacy law. So that's why I think we have to do some comparative analysis with the gold standard. So Malaysia, the first element is on data protection principle. EU GDPR and all the countries, including Malaysia, Taiwan, Singapore, Philippines, Japan, Hong Kong, Korea, Thailand, China, draft law of India, and ROU provides for that principles. Yeah, they do provide for that principles. Rights of data subject, EU GDPR, and all the legislation do provide for that. Yeah, special enforcement entity, again, all the countries and EU GDPR provide for that, except Taiwan and Indonesian draft or ROU, because we're still debating. We are not so sure what is the outcome of the discussion or negotiation that's taking place in Indonesia now. Exemption to public agency. You can see from the chart there, only Malaysia and Singapore provides exemption to public agency. What does it mean? PDPA in Malaysia and PDPA in Singapore do not apply to public sector. Yeah, in Singapore, there is a separate regulation governing collection and processing of data by private agency. In Malaysia, as I mentioned just now, PDPA does not apply to public sector. And ironically, there is no separate regulation for the public sector. Okay. And I think this is something compatible under the ROU. ROU does not give exemption to public sector. I think that's a good attitude and position to take, because PDPA or data protection law should apply to all, with some flexibilities to be given to organization based on case-by-case basis. So a blanket exemption to public sector is not good, basically. Yeah. And then a mandatory data breach notification to data subject. That's the position under EU GDPR. Malaysia doesn't have that, or PDPA Malaysia does not provide for that. But PDPA Malaysia is going to be amended. There is a proposal for data breach notification to the data subject to be inserted, to be included. The amendment, that's the requirement in Taiwan. In Singapore, it was inserted in the 2020's amendment. Similarly, in Japan, this is something new. So the old law does not provide for this, but in the amendment took place in 2020, it was included in the law in Singapore as well as in Japan. In Hong Kong, there is no such requirement, but the regulator encourages companies to inform the data subject if there is a breach or jika ada kebocoran data. That's the position in Korea, in Thailand, in China, in the draft law of India, and draft law of Indonesia or ROU. I think this is something compatible. Next slide, please. Mandatory reporting to the authority in case of data breach. That's a position under EU GDPR. No such provision under PDPA Malaysia, but again, has been proposed amendment to be made to the Malaysian Act. Then this is another proposal. Yeah, there is no such requirement under the Taiwanese law. Again, this is something new in Singapore. It was inserted in the amendment 2020. And that's a position in the Philippines, meaning that under the Philippines Data Protection, sorry, it's not Data Protection Act, yeah, in the Philippines Data Privacy Act. It's the wrong title there. Data Privacy Act 2012 requires mandatory reporting to the authority, meaning if there is a breach, you have to inform the authority about the breaches or about the breach. That's a position in Japan after the amendment 2020. In Hong Kong, there is no such requirement, but the regulator encourages companies to inform the regulator if there is a breach. In Korea, there's such requirement. Thailand, China, India, and Draft UU, Indonesia. Differentiation between personal data and sensitive data, except in Singapore, in EU GDPR, and all the countries, the legislations provide for that. In Singapore, if you look at PDPA Singapore, there is no terminology of sensitive data. Mediation to resolve dispute only in Singapore, in Korea, and Draft UU provide for that. Organizations to designate a DPO, the requirement to appoint a DPO or DPOs, yeah? And the EU GDPR, there is no such requirement under Malaysian law, but again, this is another proposed amendment, yeah? There is no such requirement under the Taiwanese law. It is mandatory under Singapore law. It's mandatory under Philippines law. There's no such requirement under the Japanese law. The regulator in Hong Kong encourages companies to appoint DPO. It is mandatory under Korean law, Thailand law, China PDPL, TIPL, Indonesian draft, as well as Indian draft. Next slide, please. Next slide. Okay. Now, I just want to have a look at some of the biggest fines that have been imposed by the regulators around the world against companies for breaching the regulations of data protection law. FTC, as mentioned earlier on, has imposed 5 billion penalty on Facebook. This is in relation to the Cambridge Analytica issue. Yeah? WhatsApp has been issued with second largest fine, 225 million euro recently. Amazon has been imposed with the 888 million fine for breaching the EU General Data Protection Regulation. Next slide, please. The regulator in the UK has imposed fine on British Airways, and the amount was 20 million pounds. The Italian authority has fined a telecom company called TIM. The amount was 27.8 million euro. Cathay Pacific has been fined by the UK Information Commissioner Office. So Cathay Pacific was lucky because the breach happened before the existence of EU GDPR. Under the old regime in the UK, the maximum penalty was 500,000 pounds. So in that sense, Cathay Pacific was lucky because, as I said, the breach happened before the existence of EU GDPR. Okay, next slide, please. Other cases, In Italy, a fine of 16.7 million euro has been imposed against another company in Italy. As we know, Marriott International has been fined by the regulator in the UK, and the amount was 18.4 million. Yeah. Another enforcement against a company based in the UK, H&M, 35 million, and regulator in French has fined Google 50 million euro. Okay, next slide, please. Next slide, please. So these are the two slides to end my conversation or my presentation. I think we can recall this statement made by President Jokowi on the 16th August 2019. Data adalah jenis kekayaan baru bangsa kita. Kini data lebih berharga dari minyak. Oleh karena itu, kedaulatan data harus diwujudkan. Hak warga negara atas data pribadi harus dilindungi. Regulasinya harus segera disiapkan. Tidak boleh ada kompromi. Itu kenyataan yang dibuat oleh Presiden Jokowi pada tanggal 16 Agustus 2019. The next slide, please. The last one, perhaps. This is a statement made by Joe Biden, President Joe Biden, recently in the State of Union address. I know it talks about a lot of things, but one of them is about the need to strengthen privacy protection, to ban targeted advertising to children, and to demand technology companies to stop collecting data on or from children, especially in the US. So to me, this is something interesting. Never before the US president talked about privacy. And if I can remember, this is the first time specific statement regarding children's privacy mentioned by the US president in the very important State of Union address. So with that, thank you so much. If you have any questions, we can discuss it in after this. And my last slide is my correspondence. Perhaps if you want to contact me, I do have my contact numbers there. So that's my email address. That's my phone number. Thank you so much again. Thank you for giving me the opportunity to share my knowledge on this topic of privacy data protection. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Professor Abu Bakar Munir. This is full of insight, right? Our student, Professor Abu Bakar, was started by the concept of privacy, and then the types of privacy, and then international regulation about data protection instruments, and move to the principles of data protection. There are 7 principles he mentioned, and comparative analysis of data protection in the international world, and examples of biggest fines. Well, this is the time for question and answer. Please raise your hand, or I prefer you to raise your hand, and I will give you an opportunity to ask directly to Professor Abu Bakar, then chat in the chat box.
Okay.
Please, Gregory, Joshua, are you there? Yeah.
Yes, Ibu.
Yes.
But
Okay.
I cannot turn on my camera because my front camera is broken.
Yeah,
It's cracked.
no worries. You can, we still can listen your voice. Okay, please, Gregory.
Good morning, Professor Bakar. My name is Joshua from the 2019, and it was very insightful. Your lecture was. I would like to ask a question regarding the automated decision making, because as you know, in most of the European countries and also Western countries such as Canada, the startups, the electronic system providers, they are mostly use their users' information to do or to fulfill the automated decision-making process. They are identifying the pattern, they are identifying the interest of the customers so they can make automated decision. So, but in Indonesia, we haven't had any sufficient regulation that allows or governs or justify the practice of automated decision-making, because if I'm not mistaken, the only way to use the customers or the users' data is based on their consent in every single aspect that the electronic system provider want to use. So I want to ask your maybe experience in Malaysia. Does in Malaysia, they also allow the use of automated decision making? And if it is, why and what are the considerations that the government used to have before enacting the justification to allow automated decision making for electronic system providers? And what are the potential of breach or negative aspect if it is not regulated properly in country like Indonesia, particularly in the industrial revolution right now? Thank you, Professor Bakar.
Can I try?
Professor, we have another two questions from students here. Is it which do you prefer? Which one do you prefer? Do you want to answer the question first, or we will continue the second?
Let's try to get two more questions.
Yes. Okay. Please, the next question from Rizka. Rizka, you can speak out. Yeah.
Okay. Good morning, Professor Bakar, Munir. My name is Rizka Livia Zahra, and I would like to ask you a question. So the urgency for strengthening children privacy, children are more vulnerable nowadays when they not realize the risk of giving their personal data or to accept some of term and condition for personal data. As more dangerous it become, shall children data protection encourage parental control or strictly ban any advertising and strengthen age verification policy across website and social media? Thank you.
Okay.
Okay, thank you, Rizka. And Adiana, the next one. Please speak up, Adiana.
Thank you very much, Mulaina. Good morning, Professor Abu Bakar. I would like to ask questions. As it is very common to find that there is a breach of that data privacy in the black market, how does certain bodies enforcing their law to such conduct, especially taking into account the same cases happen in Indonesian, as Indonesian citizens' data privacy, which found being sold by the irresponsible entity in the black market? Thank you very much, Professor.
Okay, thank you, Adiana. Please, Professor Abu Bakar.
Okay, let me try to answer the questions here. The first one is from Joshua about automated decision making. First, about the concept of automated decision making. What do we mean by automated decision making? So if you look at this concept, basically allowing the machine or computers to make decision and with zero human interference. Okay, so that is what we call as automated decision making, allowing computers, machine to make decision and zero intervention from the human being. And the second issue is that what is the position under the data protection laws around the world? If you look at EU GDPR, as I mentioned, EU GDPR has been regarded as a gold standard. So of course we have to make reference to gold standard. Yeah. So under EU GDPR, automated decision making is allowable in a very specific circumstances. Yeah. And And there are conditions attached to it before automated decision making can be allowed. The reason as to why automated decision making should not be allowed arbitrarily is that it denies basically the question of unfairness that may arise, in relations to data subject. I'll give you an example. Perhaps we can give an example better. Yeah? Let's say a bank having application or having received the forms from the data subject. Let's say someone is applying for a bank loan. Okay, so based on the form submitted by this individual, the machine will decide basically, without any interference from human being, whether or not the bank should provide loan to this data subject. Looking at the address, looking at the other things, looking at the other information, perhaps the computer will automatically reject the application. So the question is that fair? Is it fair to the data subject? Meaning that zero intervention from human from individual or human being, and the decision is made by the computers. So that is the rationale why automated decision making is not allowable arbitrarily, except in specific circumstances. For example, for the purpose of crime prevention, for example. So that is allowable. And other limited circumstances, automated decision making is allowable. Otherwise, it's not permissible. Yeah. So in Malaysia, I think there is a provision, if I'm not mistaken, in our PDPA, not allowing machine to make decision based on this automated decision making. So as long as there is an intervention by human being or individual, that is okay. Yeah, because as I mentioned just now, 100% decision made by the computers or machine is not allowable. And you can see the same provision under EU GDPR as well. Okay. Second question about children's privacy. Yes, if you look at children's privacy, it has become a very topical topic of late, simply because children depend on adults to protect their privacy. Yeah, and simply because of the fact that there are so many games, computer games, yeah, targeted at children, and then so many advertisements targeted at children, and I think because of that, that basically triggers Joe Biden to include this issue in his State of Union address. So you are right. Basically, age verification is one of the tools or mechanism to protect the privacy of the children. But the problem is that whether or not age verification is efficient, does it work? Yeah. If someone age 16, and when he or she was asked about his age, he can just say, I'm 19. So how are we going to verify that? Yeah. So I agree, age verification is one of the tools or mechanism to be used to protect children, but we have to see whether or not age verification really works. Yeah. And that is why UNICEF recently came up with some principles to be adopted by countries around the world to protect children's privacy. So perhaps you can you can have a detail of the UNICEF recommendation to lawmakers and policymakers around the world, how countries should protect children's privacy. The third one is about data breach in the black market, either black market or the the white market. The basic principle is that the data protection law should be able to protect data breaches, because if you look at the regulations around the world, including ROU Indonesia, there is an obligation on the part of data users or data controllers to protect the data, and specifically to put in place organizational as well as technical measures to protect the data. And what is going to happen if there is a breach or there are breaches? With the law, the regulators are empowered to do the investigation, to investigate the case, and basically to come up with the redress. For example, issuing warning, or even to stop companies from processing personal data. So with legislation, perhaps data breaches can be addressed. Okay, we have another question, perhaps?
Yes, we have another question from Sifa Adila. Sifa, ask
thank
directly.
you. Preliminarily, I apologize, Professor, for not turning on my camera, since my internet connection is very laggy right now. I apologize.
No problem.
I would like to ask about the H&M case. I've read somewhere that there is quite a debate on the employees' data and how they were collected. I read somewhere that it was collected through small talks and whispering campaigns. So managers will acquire the information of the details of the employees to make employment decisions based on what they've heard about the employees. And so I would like to ask about this method of data collection, whereas this is not essentially hacking or per se breaching a network of data, but this is done verbally. So if it was acquired through, for example, a gossip, would this be an intervention of data privacy as well?
Okay. Can we have another questions?
From Naufal. Please, Naufal.
The first one from Sifa, yeah?
Yes, the first from Sifa, and then the next one is from Naufal. Naufal Faiz.
All right.
Yeah.
Thank you for the opportunity, and also thank you for your previous presentation, Professor. I would like to ask a question in regards to the development of digital economy, which we already know in ASEAN specifically is related to personal data. In your opinion, how is the protection of personal data specifically in the use of e-commerce in ASEAN countries? And what are the suggestions that can be given in efforts to strengthen personal data protection standard in ASEAN countries in order to support the development of e-commerce itself? Maybe that's my question. Thank you.
Okay, probably. Another student?
Yeah, please.
If no, you can answer those two questions first, Professor Abu Bakar.
Okay, thank you so much. The first is from Afifa about employees' data. Yeah. What I would like to say here is that we have to use our social media carefully, because based on the experience around the world, the prospective employers will not only receive information from your CV, from your resume before deciding. Some prospective employers, they collect data from your activities in social media. Let me give you an example. There was a case recently in the US. You know, a medical student just graduated from the university. You know, a group of medical students just graduated from the university, so happy. And then they organize a party. And some of the students behave in a very bad manner in that party. And then they were supposed to report duty for work, basically. And some of the hospital were saying, no, we don't want you because we took a look at your social media and you behave not like a human being in that party. And you just imagine, you are supposed to report duty and the hospital says, no, we don't want you to work with our hospital. Simply because they have checked, they have basically, they saw your social media, what you have uploaded on your social media, and they say no. So what I'm trying to say here is that employers or prospective employers will get information not just from your resume or CV that you have sent to them, but also from social media or information you uploaded on your Facebook or other social media. And the question asked by Afifa was that whether or not this is allowable. Yeah, whether or not this is allowable and whether or not this is a breach of privacy. I think it's a bit tricky here because as an employer, you would like to employ someone who can give commitment, someone who can basically do the job, and you know, and they will collect data from unofficial sources as well, including your social media. Okay. The second question is about the importance of data protection in e-commerce and digital economy, especially in ASEAN. Yeah. If you look at a digital economy on e-commerce specifically, apart from the physical infrastructure, apart from the speed or the internet speed, apart from how far you can transfer data, how fast you can transfer data, there is a requirement to have legal infrastructure. So physical infrastructure will have to be supplemented by legal infrastructure. And one of the legal infrastructures to promote e-commerce and digital economy is data protection law. Apart from other legislation such as e-commerce legislation, computer crimes, and other things. So data protection laws is one of the legal infrastructures that we have to have in place to promote digital economy and to promote e-commerce. Because one of the issues concerning digital economy and e-commerce is that data should be allowed to be transferred beyond boundaries or between countries. So data protection will have a role to play to facilitate the transfer of data within countries or beyond borders of respective countries. Yeah. So that's why if you look at data protection laws around the world, including ROU, apart from principles, apart from giving certain rights to data subject, there are provisions on cross-border data transfer. Yeah, cross-border data transfer is very, very important in today's commercial and international trade world or international trade. Data should be able to flow between countries to facilitate international trade. At the same time, there must be some protections afforded to that data before it can be or they can be transferred outside the country. Okay, any other questions?
Well, we still have around 16 minutes for the discussion session.
Yeah.
And we have another question from Raisha Hasna. Raisha,
Yes,
please.
yes. Can you hear my voice?
Sure.
Yeah.
clearly.
Okay. Thank you so much, Ibu Laina, for the opportunity, and thank you so much, Professor Abu Bakar, for the comprehensive explanation. I have a question. Recently, there's a case of breach on personal data where a lot of accounts on Twitter try to impersonate official help center account on banks on Twitter, where they aim panic-ridden customers and send them links through WhatsApps or SMS to hack into their account and transfer a huge amount of money out of their account. Most of the time, there was hardly any action can be done regarding this. Is there any suggestion on how to prevent this from happening again, or how to overcome this problem, since surprisingly, this is a very common case happen to anyone, especially in Indonesia? Thank you.
Yeah. Can we have another one?
Please, another student. Do you have another question? I don't think so, Professor. Oh, yes, Alfian. From Alfian, please, Alfian.
Okay, good morning, Prof. Bakar. Thank you for your explanation. I want to ask about.
Could you please speak louder, as Alfian?
Okay, sorry. I want to ask about how far can be exception to public agency should be strictly restricted. Because mostly data protection laws are ban exception to public agency, while a few laws such as in Malaysia and Singapore personal data protection. I think that's all my question. Thank you for your thank you.
Okay. Thank you so much. Let me try. First from Russia about breach of data. Yeah. So breach of data basically happens around the world, not only in Indonesia, it happens in Malaysia, even in the US, Hong Kong, everywhere. And the question is that how these data breaches can be minimized, or what are the things that can be done to protect or to ensure there will be no basically data breaches in the future, or recurrence of the data breaches. As a common knowledge, we cannot protect 100%, our system, our data from breaches. Yeah, but we have the legislation. If we have data protection legislation in the country, at least there are some basically mechanism or some solutions that can be provided to the legislation. For example, if a data breach happens, then there will be a report. First, report to the data subject, reports to the notification to the authority, and of course, the authority or the regulator is empowered to do the investigation. Yeah, and upon completing the investigation, they should be able to identify the source of the breaches. And in certain circumstances, if basically there is a failure on the part of the data controller to protect the data, and that because that is the source of the breaches, then there are redress provided for in the legislation. So in that sense, it can serve as lessons to other data controllers to protect the data. In fact, financial penalty is one of the efficient mechanism or tools that have been used around the world to protect data and to prevent future breaches. Yeah. Second question from Alfian about exception to public agency. Yes, as I mentioned in my presentation just now, only Singapore and Malaysia, the legislations in Singapore and Malaysia provides a blanket exemption to the public sector or public agency. And I mentioned my personal opinion just now. This is not good, because to me, data protection law should apply to all, be it private sector, public sector, with some flexibilities given to some organizations like charitable organizations, religious organizations, and so on. So giving a blanket exemption to the public agency is not good. Yeah. So the exemption should be given based on the activity and based on organizations, not blanket exemption. Yeah. That's what I said in Malaysia is quite ironic. We have a law applies to private sector and there is no law applies. There is no law at all governing the public agency. In Singapore, as I mentioned briefly just now, PDPA Singapore applies to private sector and there is a separate regulations. I can't remember the exact name of that regulation, applies to public agency. But the question is still, there is still a question here to be addressed, whether or not the law applies to the public agency is compatible with PDPA in Singapore. Because when I look at the law applies to or governing public agency, there are no serious redress, for example, penalty, and then criminal offenses are not there. Okay, so that is the issue. Yeah. Any other questions or comments or input?
Yeah, please. Any other questions? I think there's no more questions, Professor.
Okay.
Yeah. And well, I think it's time to give applause for Professor Abu Bakar and saying thank you for the interesting lecture and also answering the questions raised by the students. I believe that the students have a great comprehension on this data privacy, and they would like to continue in study and study more and more. Yeah, Professor. Professor Abu Bakar, do you have a hope or a closing statement from this Studium Generale today? Please, Professor.
Okay. First, I would like to thank again Fakultas Hukum Unpad for giving me the opportunity to share my knowledge. Secondly, you can share my presentation material to the students. You can, you can send it to them. Yeah.
Thank you.
And thirdly, if they have any further questions, just let me know. I have my email address there and my mobile number. You are welcome to ask questions if you still have questions. And I hope the session has benefited all of you. And thank you so much.
Thank you so much.
Thank you to you, Dr. Laina and Ibu Sinta and the rest. And Miss MC.
You are always welcome, Professor Abu Bakar. Stay healthy, Professor.
Thank you so much.
Thank you for all participants with your active participation in this general lecture. And I will give it back to the Master of Ceremony. Please, Rizka.
Thank you, Dr. Laina. I want to give my gratitude to Dr. Laina, who has hosted our previous session. Thank you so much for leading the lecture along with Professor Abu Bakar Munir. Furthermore, a certificate will be given to our speaker today, Professor Abu Bakar Munir, by the head of the Law Department of Technology, Information, Communication, and Intellectual Property, Faculty of Law, Pelajaran University. To Dr. Sinta, I let you to give the certificate, and to the committee, I invite you to lead this photo session. Thank you.
Thank you, Rizka. Prof. Abu, as appreciation of your presentation, we would like to present a digital certificate.
Thank you so much. terputus. Terputus.
Sorry, filing is Masling is very bad. So Prof. Abu, thank you for your lecture, and this is a token for appreciation, digital certificate. Thank you, and hope this is not our final meetings, because we hope to hear from you soon. Keep well, and salam to Ibu. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much again, Ibu Sinta and the rest.
You're welcome.
Yeah, Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you to Dr. Sinta who have been giving the certificate to Professor Bakar Munir. Well, that's a wrap up of our event. Finally, we have come to the end of our Studium General today. For once again, I give my biggest gratitude to Professor Bakar Munir as our speaker today and all students who have attended today's lecture. So thankful for the insights and thank you so much for sharing with us, dear Professor.
Yeah, thank you.
Well, on behalf of Himatiku Unpad, I thank all of you for making time to join us here today. It has been our pleasure to host this event, and please fill your attendance on today's lecture. The link will be attached in chat column. Wassalamualaikum warahmatullahi wabarakatuh. Shalom. Om Santi Santi Om. Namo Buddhaya, and have a good day. Thank you.
Waalaikumsalam. Terima kasih Prof. Abu.
Terima kasih Bu Sinta. Terima
Sehat.
kasih.
Nanti
Terima
ketemu
kasih.
lagi Prof. Ya, Bu Laina.
Terima kasih Bu
Terima
Laina.
kasih, Bu Dr. Sinta.
Bu Laina, Bu Sinta, Prof. Abu, terima kasih. Thank you so
Bu
much.
Miranda, Pak Amin,
Rizka, makasih ya.
Rika. Kepada himpunan ya. Tes.